as opposed to, according to this, they found you in a drainage ditch. Everyone, the court is recessing at noon. Who is here on Richard Rodriguez?
Present, Judge.
And probation, this is an application. Court is calling 2024 CR 5668, State of Texas versus Richard Rodriguez. Can I have parties announced for the record for the state?
That done for the state, Your Honor.
Defense.
Renee Munoz on behalf of Mr. Rodriguez.
And are you Mr. Rodriguez?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, that's correct, Judge.
Court will find that the state is in compliance with discovery. Mr. Rodriguez, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the document entitled Court's Admonishments and Defendants' Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with assault family second offense? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that did you understand that by entering this plea today, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 10 years in prison.
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as the factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, the state is recommending deferred adjudication. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, sir.
Did you understand that to be your plea?
Yes, sir.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation and no harmful or injurious contact with Angela Cervantes. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offer states 1 and attachments.
No objection, Your Honor.
And state, have you spoken with the complainant?
We have been able to get a hold of the complainant, Your Honor, and they have made it clear their lack of interest in supporting the district attorney's office.
All right. You may be excused. Did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
If we may, Your Honor.
All right, the previous assault case he has, who was that alleged? Well, not alleged. Who was that against?
Angelo Cervantes.
The previous one.
Oh, Amber Rose Jimenez.
All right, Amber Rose Jimenez, and now it's Angela Cervantes.
Yes, ma'am.
What is your issue?
I don't have to issue.
Well, I mean, you're here for your second assault, so obviously there's an issue. It appears that she wanted you to leave her residence and she was breaking up with you. Was that your residence?
I was living there at the time.
Was it an apartment?
No, it was a house.
Was your name on the lease of that home? Yeah, so she didn't want you there anymore.
Right.
So you don't have anywhere else you can go?
Well, no, not at the time I didn't.
Do you have any family members?
Yes, ma'am.
Mom, dad?
Yes, ma'am.
Are they in Bear County?
Yes, ma'am.
So why can you go to them?
Oh, I can now.
No, I mean, why can you go? I would like to think, and if I'm wrong, tell me I'm wrong. If somebody were to kick you out of their home today, there is a family member where you can knock on the door and say, hey, I just got kicked out. Can I stay here?
Right.
As opposed to, according to this, they found you in a drainage ditch. So what don't you understand when people don't want to be with you?
Mhm.
Your Honor, I think he's had a lot of time to mull that over. He's been in custody the last 4 months, and I asked him specifically about this instance, leading up to his arrest. He said that it was out of character for him. He just found out it was a toxic relationship with this individual. He stated he's not going to even consider getting back with that individual, that bridge has been burned, and he's looking more so to work on himself. And
So why is outside the agreement no harm for injurious contact with Angela Cervantes?
I think it's because Judge, she didn't really want to testify. I don't think there would be any issue if it was a change to a no contact order. She didn't really want to proceed because she stated to me, and I believe the district attorney's office, that I was out of his character as long as she has known him, and she doesn't want him to be confined more than he's already been confined for the last 4 months, Judge.
All right, so it may be her experience that it's out of character for him, but he has a previous assault case. You can't go around hitting on people. Guess what? When a relationship is over, you need to leave. And if you are in a relationship with somebody, and either if it's the female or the male or whoever's in the relationship, if you get to the point that you want to put your hands on somebody in violence, don't do it. You leave. That's when you know the relationship is over. If you think someone is cheating on you, you have a choice. Either I think this person is cheating on me, but guess what? I'm going to accept it and stay with them. Or either I'm not going to accept it. I'm going to leave. It never should get to the point of violence. Do you understand?
Yes, sir.
And what is the tattoo on your neck for?
Oh, this is my daughter's name. So,
All right. That's good. I always tell people, if you're going to put a name on your body, it should be either your mom, because they're supposed to love you, or either a child, because you're always supposed to love them. When's the last time you were employed?
let's see, about 6 months ago or so. I never had a problem having a job. Always had a job.
How many children do you have?
3.
What are their ages?
Got an 11-year-old boy, 10-year-old girl, and a 9-year-old boy.
All right. So do you have the 11-year-old and the 9-year-old's name on your body? That's either yes or no.
No.
All right. So do they feel like maybe you don't love them as much because you have Sophia tattooed all across your neck? Where's the 9-year-old and 11-year-old's name?
Right. Well,
I mean, these are just questions.
I know, I just,
Down the pipeline, Judge.
I don't know how that's relevant, but,
Because I'm asking it
okay,
and I want
well,
my
I will-
questions
I will.
answered.
maybe soon get it.
No, I mean, you don't have to. I'm just wondering,
Okay.
do your children feel some sort of way if you only tattoo one child's name on your body?
She may be the princess, Judge, because
Yeah,
it's a
she
girl,
was-
so that's why he indicated to her.
Well, he should put Princess Sophia.
That may be coming too. I don't know. Hopefully not. Want to hopefully stray away from any more ink at this point. Right? Richard.
Any drug use?
No, ma'am, I've been clean for a year.
All right. And what was your previous drug?
It was methamphetamine. I was on it for 12 years and I've been recovered at it for a full year. That's proudly.
And how far did you go in school?
Graduated high school.
And what type of employment have you had?
I've been a cook for the past 13 years.
Where?
Denny's, probably every Denny's in San Antonio, Metropolitan Methodist Hospital, Northeast Methodist Hospital, Cracker Barrel, IHOP,
Breakfast places or diners, kind of things like
yeah,
that.
breakfast places.
And if you're released, who would you be living with?
My mother,
All right. Have you asked her if you can live with her?
yes, we have gone over just briefing about it, but I'm sure I will be able to.
Well, no. People always assume they can live with their parents, but did you talk to her and say, Mom, when I get released, may I live with you?
Yes and no.
What does that mean?
Kind of put it out there, but
And she hasn't picked it up. So you threw it out there and she hasn't picked it
I'm
up.
sure she will say yes. Sure she will.
So we don't know where he's going to be living. So this is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. There's to be no contact with Angela Cervantes. There's to be regular reporting by Zoom or in person. There's going to be 100 hours of community service restitution. I'm going to order parenting classes. Once he completes parenting classes, the community service hours will be deemed satisfied. And the children that you have is Angela Cervantes the mother of any of them?
No, ma'am.
There is to be an affirmative finding of family violence, the BIPP course. And I'm going to order that he stay at Lifetime Recovery.
Well, there's actually a ministry that I was staying with before. The San Antonio Christian Church Discipleship School and Ministry off Days of Honor Road.
Mhm.
And from there, kind of got taken out, moved in quick with Angela. Lived with her for about 3 months, and it was a vicious cycle of her kicking me out
All right.
and calling me back.
Oh, well, we're going to help you out right here. So I'm giving you your orders. You're going to Lifetime Recovery. There's going to be a TAP evaluation. What's the length of time of TAP in custody? All right, so that'll be a TAP evaluation while in custody as well. Follow TAP recommendations. 120 sober meetings in 120 days. Proof of employment within 30 days. No employment as a home health care provider with minors. No unsupervised contact with minors. And field visits one time for 4 months. There's to be regular random UAs, and then regular reporting. I already said regular reporting by Zoom or in person. Probation, is there anything else he needs? He's going to be staying at Lifetime Recovery, and you're going to be at Lifetime Recovery until I allow you to leave Lifetime Recovery. So there will be none of this. I just met a new girl, so I'm leaving Lifetime Recovery. Do you understand?
Yes, sir.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right. Is there anything else you need from the court to be successful?
No, ma'am.
All right, we can go off the record. So let me just tell you something. Do I want to be in anybody's business? No. I would love if we lived in a world where everybody could be in their own business instead of being in other people's business. I ask questions because guess what? The only thing I know about you is that you've assaulted a person twice, somebody that you've been in a relationship that you supposedly love. That's all I know about you. So I ask these questions so I can learn more about you. For example, the name Sophia. Who is that? Is that some other female that you've gotten so deep in that you want to put her name on your neck? Do you understand?
Yes, sir.
All right, good luck to you.
Thank you, Judge. Maybe excused.
Yes. All right, where are we on this case, counsel?
Judge, I got an offer today, communicated it to my client. We need some time to think about it.
All right, sir, how old are you? 41. All right, Ms. Ferguson, if you'll call this in 3 weeks for a plea deadline date, it is Brandy Berg.
Thank you, Judge.
And if y'all could do an acknowledgement of discovery, please.
Yes, Your Honor.
All right, we'll come back on July 11th. On July 11th, you need to let the court know whether or not you're accepting the state's offer. You understand?
Yes, ma'am.
Thank
All
you,
right,
Ellen.
thank you.
Okay, I got it written down. I'll be in touch.
All right, and if you all will come back up and just give me a moment, I have to put everything in Odyssey now, and the system runs very slow. All right, Mr. Cavazos, if you can unmute.
Unmute.
Yes.
All right,
Okay.
thank you. All right, so council, where are we on this case?
Your Honor, this morning is a final hearing on this case. This has been a long time coming.
Yes.
We've been working on this case for a couple of years now, trying to get everything kind of positioned so that we can finally do this. We've finally gotten the lab report back, and so today is our hearing under 64.04 of the Texas Code of Criminal Procedure. And so I've conferred with Ms. Moore. We've got a couple of exhibits that we would like to tell her what should get going on the record, and then we can just have quick final hearings.
All right.
Is this okay if I'm back here?
Oh, yes, that's fine. Just give me a moment. All right, let me just find your motion. It even gave me a temporary file because it went missing. Just 1 second. All right, do you have a copy of yours?
I don't have a hard copy. I can send it to you. Will it email it to you or-
Yes.
You got it.
Okay. And I'm still looking to see if I have the file. I mean, I have the only motion I have in here so far is the motion for DNA testing. That's it.
That would be the motion. And so what happens after that is that they actually go and the court granted that motion way back. I think it was.
Yeah. So has the DNA testing been done?
DNA testing has been done. And so the court actually did the analysis under 64.03.
Okay.
And so now we have to do the final hearing to determine whether or not the evidence that came back would have exactly what the language is.
The exact words are, had the results been available during the time of the offense, it is reasonably probable the person would or would not have been convicted.
Okay.
That's
And see, I'm just trying to find that in here. Those words, because I don't see that. The only thing I see is we're requesting DNA testing. That's all the motion said. So the DNA testing was done and I'm reading the motion. And
But I can give you kind of just a factual,
Sure.
historical update.
all right, let's go on the record. Court is calling 2010 CR 5796, State of Texas versus Jose Maria Cavazos for the state
Foreign somewhat to the state.
defense.
David McLean for the petitioner.
All right, and state you may proceed.
Yes, Your Honor, and before we begin, I just would ask the court to take judicial notice of the court's file, all the pleadings on file, including the plea bargain agreement, stipulations to evidence. We ask the court to take judicial notice of all of that.
Any objection?
No objection, Judge.
So just for a brief background, Your Honor, this is involving a case where there was a plea to 1 count of aggravated sexual assault of a child on August 5th of 2011. Mr. Cavazos was sentenced to 15 years confinement. We are now here on the Chapter 64 motion that was filed by Mr. McLean on behalf of his client. The court granted his testing. The testing has been completed. And so we are now here on the final hearing after the testing has been completed. I will tell the court, just for background knowledge, there was some DNA testing done during the time of the investigation, prior to the plea bargain agreement. And I don't know how much factual, if we want to get into this now or not, but I can.
Go ahead.
So at the time, Your Honor, before the plea, there were several items given by the complainant's mother to law enforcement. Just for a little bit of factual knowledge, the allegations are that a 4-year-old complainant was spending the Thanksgiving holiday with her grandmother.
Right, and just 1 moment. Sorry to interrupt.
Sure.
By Zoom, we have your client. Is there any objection to Mr. Cavazos appearing by Zoom? State
No objection.
No
defense.
objection, Your Honor.
Mr. Cavazos, do you have any objection to appearing by Zoom?
No, ma'am. No, ma'am.
All right, you may continue.
Thank you, Judge. 4-year-old, the complainant made an outcry that during that Thanksgiving break, Mr. Cavazos sexually assaulted her. There were 4 counts in the indictment. Mr. Cavazos pled to 1 count. During that investigation, because the mother did not exactly know which clothes the child was wearing when she was sent over to her grandmother's house, she gave law enforcement 6 pairs of blue jeans, 8 shirts, 2 shorts, 3 socks, and 4 pairs of panties. At that time, 2 pairs of the child's underwear were tested. There was no DNA, there was no semen or blood found on the DNA. So there was, the only thing at the time was the child's, I guess, outcry. So there was no DNA as part of the plea. Once once you granted DNA, some of these items were tested. 2 of those blue jeans were tested. There was 2 cuttings out of those blue jeans. That was what was tested. That's what we have the results on today. And so that's kind of where we are today.
All right, and with the regards to the blue jeans being tested, is there an agreement on what the results are?
Yes, Your Honor.
Yes.
All right, and what are those results?
Judge, if I may, to submit to the court, I'm going to submit first Petitioner's Exhibit 1. This is the forensic serology report from Bexar County Criminal Investigation Laboratory. This is dated January 6, 2010. This is the list of the items that were originally submitted for testing. And as was previously identified by Ms. Mora, the only things that were tested revealed no semen, no blood, and no matching DNA to my client.
All right, so any objections to Petitioner's Exhibit 1?
No objection.
Then Petitioner's Exhibit 1 will be admitted without objection.
Second thing we're going to admit is Petitioner's Exhibit 2, which is the Forensic Advantage Discovery Packet. This was dated March 7th of 2024. This has been previously tendered to the state for review. This is the results from the Bexar County Criminal Investigation Laboratory. I'm going to I kind of dog-eared it for the court for easy reference, but it shows that the same unknown individual was identified in cutting number 1 from the blue jeans and cutting number 2 from the blue jeans. And
Oh, sorry, if you'll just slow down for the court reporter.
I'm sorry. And Jose Marie Cavazos is excluded as a source of this unknown genetic profile. And so I would submit Petitioner's Exhibit 2 to the court.
Any objection to Petitioner's Exhibit 2?
No objection.
All right, then Petitioner's Exhibit number 2 is admitted without objection.
Judge, I have just from the state, we don't have any agreements in this case. The state is opposing any sort. We would be asking the court to find that if the results have been available, he still would have been convicted under his plea. These cuttings, as you look at the report, I'm sure the court will review them. It shows that there was an unknown female profile found on those cuttings. So of course, his client would not match an unknown female profile. Additionally, Your Honor, those 2 cuttings really didn't have enough evidence of anything on there to do the YSTR chromosome testing that the applicant was requesting. So there was nothing, they weren't able to get a conclusion. So what we have here is essentially he is excluded as an unknown female contributor on the genes. So for those reasons, Your Honor, we're asking the court to find that had those results been available, it's reasonably probable that that he would have been convicted. There was no DNA at the time of the plea. There's still no DNA. It doesn't change the position that we're in. So we would ask you to find that those results are unfavorable and that wouldn't change the outcome of the case.
All right, defense.
Judge, I was appointed on this case quite some time ago, and since then we've had the opportunity to try and get the DNA testing done that was not done in this case. And from my client, from Mr. Cavazos' perspective, that was pretty important because the DNA testing, as Ms. Zamora stated, the evidence that they had at the time of this plea was, hey, we don't have any DNA matching you, but we've got all these other items that were never tested, and they're going to come back and they can show that you're the contributor.
Yes, you can.
Mr. Cavazos, from my conversations with him, entered into a plea with basically that big unknown hanging over his head. And we think that because what we submitted when we asked to get this tested was to have all those items that were in petitioner's exhibit 1 tested for DNA. Everything that got tested was those 2 blue gene cuttings. So we can only assume there was no DNA on anything else. And so what we're telling the court is, had that information been available to Ms. Cavazos at the time, then Mr. Cavazos would not have entered into this plea bargain and would have decided to go to trial instead. And having no DNA matching him and only having a outcry from a 4-year-old, that would have changed the outcome of this trial. I think a jury very likely would reasonably have said, no, with results excluding Mr. Cavazos, would have said, no, Mr. Cavazos is not guilty. And so our position is that it would have changed the outcome of this trial. And the language, again, is the court is to determine, I'm sorry, I'm in the wrong section.
Well, here's my question. Would it have changed the outcome of the trial, or would it have just changed whether or not your client entered a plea?
And that's the question. Had the results been available during the trial of the offense? Because my client, and I can call him if Mr. Cavazos wants to testify. His information to me is, I would not have entered this plea had I known this information.
Right.
And so then we would have had a trial. And if those results had been available during the trial of this offense, it's reasonably probable that he would not have been convicted.
All right,
because
so-
it conflicts with what the outcry statement.
All right, so the court's focus, and correct me if I'm wrong, the court's focus is not whether or not he would have entered a plea. It's whether or not the outcome of a trial would have been different if a trial would have taken place. Is that correct?
Yeah, I think one thing needs to be clear, Judge, Chapter 64 is not a vehicle for relief. That would be a writ. So if you were to find that this is a favorable finding, then he could take that evidence and file a writ and then challenge his conviction that way. So we're simply here today on a Chapter 64 to determine whether or not this evidence that was tested was either favorable or not favorable. And I'll give you the exact language. And if that evidence that you've seen now was available during the time of the offense, it is reasonably probable that the person would or would not have been convicted. So what, and at least in my opinion, he's giving you is an exclusion of Mr. Cavazos of a female contributor. That's all. So is that favorable or not? And would that, if that had been available, would he or would not have been convicted? It's kind of hard because we have a limited record on the plea, but this does not keep him from filing a writ later on either an ineffective or whatever he wants to do.
But I just want Mr. Cavazos to know the court's focus is not on whether or not he would have accepted a plea or not a plea. It's whether or not would there have been a favorable outcome at trial.
I completely agree.
So I just want you to know that, Mr. Cavazos. So the issue is not whether or not you would have accepted a plea or not accepted a plea. Under the law, I'm just here to make a decision about potentially whether there would have been a favorable outcome at trial. Do you understand?
Yes, ma'am.
All right. All right. So what we'll do, I'm sorry.
I have a question.
Yes, you can ask your question.
Okay, the attorney that I had that was representing me during the court time told me that I had to sign the plea.
Oh, no,
because-
Mr. Cavazos, let me just explain to you. One, if there's something you want to say that your attorney said, that is for another hearing. That is not specifically for this hearing. And you probably should talk to your current attorney before you do that.
Okay,
Okay?
okay.
All right. So for both parties, if you want to submit a brief to the court, you're more than welcome to do that.
Okay.
If you all don't want to submit a brief to the court, then I will read petitioners 1 and 2 and make a decision.
Sounds good.
All right.
Do that.
Y'all want to submit a brief?
I'll submit a brief, Judge.
All right. So how much time do you want?
Given that I have like 3 appeals going right now.
Oh, no, just let me know.
If I could have 30 days.
All right.
Does that work?
Ms. Ferguson, on Cavazos, if we'll recall this in 45 days.
That'd be great, Judge. Thank you.
All right.
And I'll file an amended state's answer. for the
All right.
court to consider.
So,
It won't be long, but
all right, so what date? All right, so your briefs will be due on August 8th. And then Ms. Ferguson, let's set this for 2 days thereafter, and then we'll have another hearing and I'll give you my ruling.
Yes, Judge.
All right, so then you all will come back on August 13th.
which is a Tuesday, can I get any other
Yes.
day?
All right, any day other than Tuesday, Ms. Ferguson.
That'd be perfect, thank you.
All right, so we'll do it August 15th. And councils, if for any reason you're not prepared on your brief by that day, just let the court know so that we won't have him by Zoom. All right, so Mr. Cavazos, tentatively, what's going to happen is on August 8th, both the state and your council will submit briefs to the court for me to review. And then we'll come back on August 15th. And on August 15th, I'll make my ruling. Do you understand?
Okay. Okay.
All right.
So,
All right, we're off the record. Council, we all know what's happening with Odyssey.
Oh, yes.
So if you all could, I know how they want you to file it, but if you could make sure that I have a copy just in case it gets lost in the,
I've started.
I'm
doing that
continuing.
more And more and more, and I will make sure you have a hard copy.
all right.
Gotta
Thank
get it.
you.
Can be excused, Your Honor.
All right, yes. Do you need to speak with your client?
No, I can call him later. I've got direct lines to him. And so Jose, I'll touch base with you after court this morning, okay? Okay,
okay.
All right, thank you.
thank you.
All right, you're welcome. All right, have a good one. Who's here? Nathan Cruz. All right, Norma. I need a jury trial date on Nathan Cruz.
Judge, I'd like to make a record on this real quick.
Sure.
Judge, this case was originally set. for
Well,
trial-
in order to make a record, I need to call the case.
Oh, I thought you did. Sorry.
No. All right, court is calling 2023 CR 9657, State of Texas versus Nathan James Cruz. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
For the defense?
Stephen Gilmore from Mr. Cruz.
Are you Mr. Cruz?
Yes, ma'am.
All right. Defense, you'd like to make a record?
Yes, Judge. This case was last set for trial on Tuesday of last week.
Yes.
We were recalled to Friday. Mr. Cruz was not transported Friday. Had this case recalled for today. I announced ready on Tuesday, would have announced ready on Friday, filed what is defendant's second assertion of his right to a speedy trial. He's been in custody as of last Friday, 312 days. Was arrested when he was 17 years old. He's been in continuous confinement. We made our initial speedy trial assertion on August 9th. On August 14th, I filed a writ challenging probable cause. On August 24th, I filed a motion for examining trial. None were ever set. State indicted the case without conferring with me, though I attempted to. The state is not ready for trial. They've given me every indication that they will never be ready for trial. And so I would like the state to be asked to make an announcement on this case on the record that they are not ready for trial. So that I can continue pursuing the speedy trial rights. I can't agree to a reset of the continuance or else I waive his speedy trial rights. So I'm objecting to the reset and I'm asking the state to put their not ready announcement on the record.
All right, and just so everyone is aware, I'm only one person. I can only try one case at a time. And last week, we were in a murder trial. State.
So yes, Your Honor, we were in a murder trial. I wasn't the one that announced last Tuesday, so I don't know what they announced. At this current moment, we weren't aware that it was gonna be set for trial today. We thought it was gonna be reset for another trial date, so this case we wouldn't be ready. But if the case is reset, we would attempt to see what we can do on that.
As an officer of the court, Judge, I can tell you that ADA Garahan told me and has been telling me that the state is not ready. And it was not ready because of the murder trial. They are not ready on this case because there are necessary witnesses they don't have and they will never have. And so the state's never going to. be
Well,
ready.
let me stop you all right there. Ms. Ferguson, have this brought back for June 24th for trial.
Thank you,
There we
Judge.
go. He'll be dressed.
Thank you, Judge.
Is there anything else?
Nothing further, Your Honor. May we be excused?
Yes.
Thank you, Judge.
Well, just one moment.
Oh,
I need an acknowledgement of discovery file.
but I'll do it again if not.
All right. And Ms. Ferguson, having brought over dress for trial on Monday. All right, where are we on, who's the attorney on Christopher Weezer?
I am, Your Honor.
All right. And for the state?
Just that, this last name with an H.
Yeah.
Oh, yes, okay, sorry.
Yes, Judge.
All right, where are we?
So I'm on two of his felony cases, Judge, the possession of controlled substance less than a gram
Mhm.
and repeated violation of bond protective order. I
Yes.
reviewed the discovery. The discovery seems intact on those. However, he does have two assault family violence cases with attorney Greg Dismaris. He's set to appear with the court on that June 25th, so
Okay.
about 5 days from now, Judge.
All right,
But it's my understanding that he's going to confirm with the state's attorneys and likely reach a resolution on that date. It's just since I'm not on those assault cases, Judge, I can't advocate on.
all right, it's set for June 20th.
And I think the other cases, Judge, might be set for June 25th.
Okay.
The other two.
No, all of it says June 20th in the file. So Norma, when is Weezer set on his other cases?
Yes, Judge, that may have been attributable to me because I'm gonna be out next week and I had requested some of the cases to be moved, but upon looking, I saw that Mr. Desmaris was in fact on two of his other cases.
DeMarais, that's how he says he
DeMarais.
pronounces it.
Okay.
When we were practicing together, it was not pronounced that way.
Oh,
So I
you guys
had to-
practice together? Oh, okay.
Well, when I say practice together, he was a defense attorney, I was a defense attorney.
I have to remember that, Judge. I was kind of.
It's either now he pronounces it DeMarais or DeMarais.
I'm not sure, Judge, but please don't tell Greg I don't know.
All right, Ms. Ferguson, on Christopher Weezer, does he have a date for June 25th? I see it all for today.
It's all up for June 20th. I want to say when I. Yes.
Yes.
Christopher Weezer.
All right, I don't know why, because I have 20th in every file. All right, we're gonna come back on June 25th.
Judge, I think Renee had requested him to be brought over early.
Ah.
That's right, Your Honor. Is it all right, if Mr. Desmarais, comes, he said he would be here on the 25th date. And since he has the more serious offenses, I think that mine are likely gonna be TIC dismissed, Judge.
Of course.
Okay, appreciate that.
All right, thank you so much.
Thank you, Judge.
All right, thank you.
So put it back on the 25th.
Yes. And let Greg know. All right, so this was reset, so you could go over discovery.
Judge, yes, we got an offer today from the state, so we just asked for a reset, Judge.
All right, how old are you?
19.
All right, Ms. Ferguson, recall this for 30 days for plea deadline date. And it's Denzel, how you pronounce your last name?
Apia.
Apia, all right.
Judge, I have a vacation letter until the week of the 22nd, so is it possible to get that week?
All right, Ms. Ferguson,
It's about 30 days.
what are you, is your vacation letter the week of the 22nd?
Judge, it's from the, I think the 4th to the 19th, so. The
All right,
19th is
if you put
Friday.
it the week of the 22nd, Ms. Ferguson. All right, July
Your Honor.
23rd is your plea deadline date. Make sure an acknowledgement of discovery is signed. And once you've done that, you're excused.
Thank you, Judge.
You're welcome. All right, who's here on Mariano Rendon? All right, is this the same as Ray Martinez's client?
Yes, Judge.
All right, so the plea deadline date on this case is going to be July 25th.
That's fine, Your Honor. And we did get an offer today, and may we be excused.
Once you sign the acknowledgement of discovery and your client signs the reset form, you are excused.
I was gonna ask the court, because we had some e-filing issues last week, I wasn't able to do the e-file request. Can I have till the next court setting to do the discovery
Yes.
acknowledgement, Judge? Because I just need to go and request some of the videos and things like that.
All right, thank you for dressing appropriately for court. So when you come back on the 25th, you'll need to let the court know whether or not you're accepting the state's offer. Do you understand?
Yes, Your Honor.
All right, you're excused once you sign the reset form. Trevor Morse. All right, so where are we on these cases, counsel?
Yes, Judge. In speaking with my client, I think there's some significant mental health issues.
Okay.
I haven't been able to assist in his defense at this time, and I don't think he has a rational factual understanding of the proceedings, Judge. So I wanted to see just an abundance of caution about filing for a competency evaluation.
All right, Ms. Ferguson, on this case, Morse, can you give me a 45-day reset for competency? And counsel, will you file that motion?
Yes, Judge, I'll file that today.
All right, thank you. And Mr. Morse, we're going to bring you back in 45 days. That's just to see where the evaluation is. All right, so we'll come back on August 5th.
Yes, sure. Thank you.
All right, you're welcome.